Brown versus Board of Education ended state-sponsored segregation in the U.S., but did you know the legal argument that actually won the Supreme Court case? So ultimately, the goal of Brown was to make sure that public schools did not have state-sanctioned segregation. And by that, we mean segregation that was either created by or endorsed in some manner or woven into the nature of this country. So there was a pretty long road leading up until Brown. Going back to the early part of the 20th century, both the NAACP and LDF were very concerned with making sure that Black people had full citizenship under the law. And one of those ways was making sure that there is equality in public schools. So in 1929, the NAACP received a grant in which they were able to think about creating large-scale legal campaigns to enforce the constitutional rights for Black Americans in the South. And part of that campaign was thinking about unequal funding in public schools based on race. A year later, in 1930, the NAACP hired Nathan Margold, who researched legal avenues to launch campaigns that allow Black people to exercise their constitutional rights. He wrote a over 200-page document known as the Margold Report, and this summarized the rights that citizens are given under the Constitution, and it outlined a path forward to dismantle segregation. So most importantly, this report confirmed what the NAACP already knew from previous surveys from clients and community members, and that was that the Supreme Court's concept of separate but equal in Plessy v. Ferguson rarely came into fruition because separate did not yield equal results. So Margold recommended that the NAACP ramp up its legal work, which is previously doing some small-scale cases for equal resources, and build it towards a broader federal litigation strategy that will rely upon the 14th Amendment of the U.S. Constitution to strike down state-sanctioned segregation. And this was the strategy that we saw in Brown. The Brown case that we know of today went before the Supreme Court because the court consolidated 5 cases from across the country into one. So across those 5 cases, it could be seen that either Black students were outrightly denied admission to their nearby white schools because of their race, or they were witnessing their all-Black schools being completely under-resourced compared to their nearby white schools. So each case had very unique discriminations happening, but the court decided to hear them all collectively, and Brown was essentially saying that public education is a right, and the 14th Amendment's Equal Protection Clause says that racially segregated schools deprives people of their right to public education. So the 14th Amendment's Equal Protection Clause essentially states that as citizens, we are protected from government actions that could discriminate or treat people differently on the basis of things such as race, sex, and national origin. And historically, I think it's really important to note that the 14th Amendment was what we call a Reconstruction Amendment. So the 13th, 14th, and 15th Amendments were passed following the U.S. Civil War, and in particular, the 14th Amendment's Equal Protection Clause was to ensure that everyone had equal rights, particularly formerly enslaved Black people. They were also, in Thurgood Marshall's time, sometimes the only legal protections that we had on a national level to address racism that was happening through the law. So Dr. Kenneth Clark and Dr. Mamie Clark were 2 Black psychologists who were experts in studying how young children were socially and psychologically impacted by racial segregation. Before their work appeared at the Supreme Court level in Brown, their study, which we call the doll test, was part of some of the other 5 cases that were consolidated into Brown. The test presented Black children with dolls across a spectrum of skin tones, so some were light and white, and some were dark and black. And they asked the children to look at the dolls and tell them which ones they believed were nice, which ones they believed were bad, and which ones they believed were most like themselves. The researchers found that the Black children tended to favor the white dolls and believed that the Black dolls were bad. And they also thought that they looked most like the white dolls, even though they were Black. The researchers concluded that even as very young children, the Black students were taught that they were inferior due to their race. When this test was added into Brown, it showcased a really, really powerful combination of working together between lawyers and researchers. And the groundbreaking study that was this doll test revealed that even at a very young age, Black children were very aware of discrimination, and they also internalized it, and they could express their understanding of it. LDF had so many brilliant women who were actively involved in Brown. Some were plaintiffs, some were lawyers, some were organizers, and others were policy experts. And two of my favorite were Polly Murray and Constance Baker Motley. Polly Murray authored a seminar paper on whether the Supreme Court should overturn the civil rights cases of 1883 and Plessy v. Ferguson. And Murray later learned that LDF attorneys read her paper and used her strategy as they prepared the Brown briefs. Polly Murray's brilliance was complemented by Constance Baker Motley's lawyering at LDF. Motley was part of every major school desegregation case that LDF had from 1945 to 1964, and she served as one of the architects of LDF's school desegregation strategies. In addition, Motley wrote the original complaint for Brown, so we have a lot to thank her for because of her brilliance. LDF was very concerned about Black teachers in the post-Brown world and did start working towards creating strategies and programs to protect them. In January 1955, pretty soon after the Brown ruling, LDF created the Department of Teacher Information and Security, and they were charged with protecting the Black teacher from arbitrary and discriminatory loss of employment. After the Brown verdict came down, not every state made very fast progress towards school desegregation. Louisiana, for example, made very little progress even several years after Brown. And so, to ensure that the 14th Amendment to Equal Protection Clause extended full citizenship to Black students by allowing them to have quality public school education, legal organizations like LDF supported plaintiffs in their cases. In 1965, plaintiffs in Thomas v. St. Martin Parish School Board filed a federal class action lawsuit on behalf of Black students challenging the district's segregated schools. After 58 years of litigation, in June 2023, the court approved a settlement agreement between the plaintiffs and the school board. LDF was successful in convincing that federal court to order the school district in St. Martin Parish to address racial discrimination and disparities in school discipline, teacher hiring and retention, and student access to college preparation courses, in addition to other efforts to advance school desegregation. LDF has quite a large docket of cases regarding school desegregation today, so even 70 years after Brown, our lawyers are still working so hard to bring us closer to Brown's promise.